Welcome back, Blue Grit family. We have got a special guest today, one of our regional TMPA attorneys, the man, the myth, the legend, Randall Moore. Man, welcome.
Glad to be here.
Yeah, absolutely.
I'm waiting for that applause that you hear in the background.
Yeah. Man, before we dive off into kind of what we're going to talk about today, you guys hit that subscribe button. Go ahead and download these podcast episodes. Again, this is kind of how we grade our analytics. My co-host is he's out of town today, Clint McNear. He's got some business to take care of. So, man, it's unfortunate he couldn't be here today, but he is here in spirit, and I'm sure he'll be tuning in and grading me whenever he listens to this episode. So, it's such a pleasure for you to join us today.
Well, I'm glad to be here. This is a topic that I'm very passionate about.
Yeah, absolutely. It's a big topic across the state. I know that. So, Randall, let's before we dive off into the topic, where did you grow up at, and how did you get involved in TMPA, and where'd you grow up, and let's just dive off into that first.
Yeah, I was born in West Texas, but we moved to the Arlington area. I went all the way through college in Arlington. University of Texas at Arlington, then went to SMU Law School. I've practiced in the Fort Worth area, or that's where I'm based out of my whole almost 40 years now.
What part of West Texas did you grow up in?
Lubbock, and then Amarillo, and then my dad was a trailer salesman, so he went from Lubbock to Amarillo, and then we came back to Fort Worth.
I got you. And what brought you guys to Arlington?
He got transferred to the regional office at that time, which was based in Fort Worth.
I got you. And then did you always know that you wanted to be an attorney?
Well, no. I tried several things. I actually tried to get into federal law enforcement, and it was just it was too hard at that time to do it without either an accounting degree or a law degree.
Yeah.
So I went to law school to get in with the FBI and interviewed, and I think I was 230 pounds at the time, and they said I had to weigh 195.
Yeah.
They were doing the actuarial tables at that time, and I couldn't do it. So my wife's dad was a professional baseball player, and she said she didn't want to move, so I joined the Tarrant County District Attorney's office and started out there.
Wow, that's amazing. Did you enjoy working there?
I loved working for the District Attorney's office. I did it for 3 to 4 years for going out, and it was a great place to start, great place to learn. We had some excellent prosecutors at the time and some excellent defense attorneys. And so that's where I actually started out working with law enforcement very closely at that point in time.
We had District Attorney Harrison County District Attorney Reed McCain on several episodes ago, and he actually made the recommendation that he believes people that are getting into the law profession as attorneys, he feels like it's instrumental for them to be somewhat introduced as far as working inside a DA's office as ADAs. As a part of their internship, I guess you could say it, or to start off working there because it's so instrumental. And there's actually a recruitment crisis going on right now with state offices. Did you see that whenever you worked for Tarrant County?
Actually, when I started back in the mid 80s, people getting out of law school were going for the higher paying jobs, and the district attorney's office paid relatively lower than the bigger firms. But my opinion on it is, the medical profession has an internship and a residency, and the legal profession doesn't. So I viewed my time at the Tarrant County Criminal District Attorney's Office as an internship.
Yeah.
By the time I got out 3 to 4 years after starting, I was 3 to 4 times ahead of anybody else in my class as far as experience.
Yeah.
And I just think that that's been a major foundation for my my law practice today.
Well, and for the listener, watcher, viewer, some people don't, and I didn't, certainly until I went to work for the sheriff's office and became really in tune with our DA's office there in East Texas. They may not know really how a DA office is really structured. You've got misdemeanor, felony, and kind of how that structure is chief deputy or the chief prosecutor. Can you kind of explain how the Tarrant County DA's office was trying to kind of structure and where you fit in there in that puzzle?
Well, at the time, Tarrant County's office was split into a criminal section and a civil section. Mm-hmm. I started out in the criminal section. and then moved over into the civil section. And because it wasn't nearly as exciting as the criminal section, I would wander down and do some criminal cases as well. We had misdemeanor felony courts with court chiefs and ADAs assigned to each court.
Right.
And then we also had special units starting at that time. We had the gang unit that started about the time that I was there. We had prosecutors that did nothing but forfeitures and things of that nature. We had an appellate section, and then family violence came into being. So it's a very complex organization in a county like Tarrant or Dallas, where Harris County, where you've got, I think at the time I was there, we had 250 people working at the DA's office, and that was in the mid '80s.
Oh wow! And what would a civil side of the DA's office, what would that include? So that way the listener or viewer that don't know, what all would that include?
Well, it's changed a little bit now, as I understand it. But back when I did it, we did protective orders on the family violence. We did breath test refusal cases. We did parent-child termination cases. We represented
CPS type stuff.
Yeah, we represented the hospital district, represented the county in tort claims, yep. And we represented Tarrant County in the civil rights 1983 causes of action, because you have jail, yeah. And there wasn't enough lawyers to go around, so everybody got their civil rights cases to work on. We did mental health commitments, and we did whatever overflow was there.
Yeah. So that's kind of how you got your introduction to law enforcement. Your contacts. Is that really what your introduction with TMPA was, with working in the DA's office then, or was it kind of later on down in your career path with TMPA?
Well, I started representing police officers, law enforcement officials, firefighters, things of that nature, while I was at the district attorney's office, because in Tarrant County, the criminal district attorney represents the sheriff and the constables. And so we had cases where we represented them. When I got out, whenever they had a conflict and the DA couldn't represent the officer, then I did work for several cities representing officers and firefighters as well. I started doing work for TMPA, I believe about 10 years ago, when I think it was about the time that Arlington started having a large membership of TMPA members, and they were looking to add some legal help in the Tarrant County area.
Yeah. In fact, just recently, they just hit their 20-year mark. There's two chapters there in Arlington. You've got the other side, Arlington Municipal Police Association, which is us, and then there's the other, POA that's there, and they just hit the 20-year mark late March. So congrats to them, Arlington POA. Congrats to you guys, and you're right. There has been a big growth there at Arlington, as well as you're very impactful there at Grand Prairie. A lot of legal calls that come in ask for you. So that's kind of where you got your start with TMPA, was about 10 years ago, you said, right?
Right, and I think one of the things that Randy DeBrava appreciated was that being a former trial lawyer, trying complex medical malpractice cases, that TMPA does have litigation, and there're just not that many lawyers that are younger than me that have gotten the kind of experience that lawyers of my era got. We had workers' compensation cases. We tried a lot of cases. Yeah. And of course, at the DA's office, I think I tried 120 cases in 3 years. They weren't all big cases, and then some of them were, like half-day cases, but we tried a bunch of cases. And so TMPA sends me to El Paso, to San Antonio, Amarillo, wherever they need somebody with that type of litigation experience.
Yeah, and that's what I like about it, the fact that I know that whenever I do take a legal call and it's a bulldog type case, and now don't get me wrong, we do have some phenomenal attorneys, but one of your strengths is that you are a bulldog and you're a go-getter, and you're you don't really put up with bullshit for all intents and purposes, and so that's one thing I do love about you, and it does have to meet the right atmosphere. your style of representation in certain situations may not be best, but when it does fit, you're the right person for the job. And that's what I find it's awesome. It's a great fit for the right situation.
Well, it's, people ask me how I got to be that way, and I said, I guess it's just a gift, Some people, they can walk in the room and I piss them off. And sometimes there's nothing really wrong with that.
Yeah.
So, I one of my favorite books is the 33 Strategies of Warfighting, which I read because when I first started practicing law, it was all-out assault, never surrender, no retreat. And I read this book, and it started talking about how, military-wise, that retreat is sometimes an effective strategy to set up an offense. And so as I've gotten older, you can only lose your arms and legs so many times. You can't regroup like you used to. So I've tried to do things the second half of the game a little bit more wisely than I did at first. But and in this arena, there's more of a market for aggressiveness than there is in a courtroom where you got to be more civil, which I can be, and I have done that, and it's very painful, but I've done it. But what I found is a lot of times, when I first started doing this, I had to call Ranger Brava and say, do we win any cases? It seems like I lose most of my cases, and because the odds are stacked against us so many times.
Yeah.
And what that officer wants is they want someone to stand up and talk to the other side for them because they can't. Mm-hmm. And so when you go in and you give your officer an aggressive representation, if that's what they ask for, and if that's what the case calls for, they may not win, but they walk out of there and they think, I've had my day. And they can start getting closure towards whatever was taken from them. They don't go sell their job, and they don't give it away most of the time. Somebody comes and takes it. And the psychodynamics of that are just like someone burglarizing your house. And so, giving an officer that opportunity to say what they can't say in a chain of command meeting is a lot of times that's really what they need to move forward. And that's what we do.
Well, and the fascinating thing is that you're one of many, again, phenomenal attorneys that we do have on staff. Well, I mean, as far as contract, and you really are the extension of our motto of the voice of Texas law enforcement. And I think you're right. I think that sometimes that, the reality is that we don't win every single case that comes through here. That's the reality. Take it for what it is. Right now, on record, I will say right now that we do not win every single case that comes through here. We don't. But by God, we do stand up and say, like, right is right, wrong is wrong. And you're going to get to stand up and say, this is not right. And I think that some members want that. I think that they would rather, I'm not going to say lose their case, but I would say that the member wants to have their day to where they get to call their admin to the carpet with their attorney right there with them.
And what makes TMPA unique, in my opinion, and when I first met with the gang and told them, that I wanted to do work for TMPA, the only condition I had is if you give me an officer to represent and there's a lieutenant or somebody else above them that we also represent, don't call me off, because I'm going to take care of my officer.
Yeah.
And TMPA will hire 2 or 3 different lawyers on a case if they have to, so each officer can get that representation they deserve instead of we're looking out for the good of the association over the good of the officer. And that's, I wouldn't have done it any other way. I mean, I don't want to sacrifice my client's defense because of the greater good of the association. Yeah. That's not something's going to happen.
That's right. That's right. Well, I know that one of the things that you're extremely passionate about is this huge topic that is going on across the state, and it has to deal with Brady. I know that it's plaguing the Tarrant County area, it's plaguing Dallas County, and quite honestly, it's an issue statewide. So what's your thoughts on Brady, and kind of dive off into what your thoughts on?
Yeah, so let's talk about, first of all, what is the Brady List? And a lot of people, they think that there's this document in the district attorney's office that they unfold, and it's, "Hear ye Brady List." and they may have a database or a document that they call the Brady List, but there's per se there's not a Brady List. Brady originated with Brady versus Maryland, a 1963 Supreme Court case, where the Supreme Court of the United States ordered that in a criminal case, the prosecutor is required, has a duty to turn over all evidence that might exonerate the defendant. And so what I noticed is that really wasn't that big of a deal. All DAs have had that duty since 1963, and maybe sooner than that based on case or state law. It started becoming a big deal about 7 or 8 years ago with the St. Louis incidents that were going on, when it became socially acceptable and desirable to target police officers for political reasons. At that point in time, the outcry for reforming what was going on in these prosecutions, that's when I really started seeing it become a big deal. The Texas legislature passed 39.14 of the Code of Criminal Procedure, and that is a discovery procedure. So basically, what is required is that the district attorney shall produce, and there's this long list of materials that they have to produce to the defense. And then subpart H, which is the part that I think we're here to talk about mostly, is notwithstanding all this other stuff that you have to turn over, the prosecution shall disclose exculpatory impeachment or mitigating evidence. And so that's when it started amping up, and district attorneys started requiring police departments to report disciplinary actions against police officers, not just the ones that they found out about through investigating the case, because if you don't ask, you don't know.
Right.
But now the district attorney's office, now most of them require their departments within their jurisdictional area to report to them disciplinary actions taken against police officers. So when I'm talking about the Brady List, I'm talking about just a police officer that has a disciplinary issue or some other issue that gets to the attention of the district attorney that then has to be disclosed to the defense because it might be exculpatory, impeachment, or mitigating evidence. Now, the intent of that was good. Let's make sure that we're not, running people through criminal trials and taking away their life and liberty without making sure that they are given due process. And if you're hiding evidence that would otherwise result in an innocent verdict, then that's just not right either. So the intent was to make sure there was a level playing field, that the defendant got the evidence that the state was aware of so that they could get a fair trial and their constitutional requirements could be met. The problem with that is twofold, in my opinion. Number one, it has been turned into a political weapon in some cases. Now, the majority of the time, most district attorneys mean well. They do the right thing. It's not that they don't make a mistake, not that we don't have differences of opinion, but every now and then, and I get a lot of Brady cases, I see that it's being used as a political tool. Why else would you bring up something that happened 20 years ago against a guy that's about to run for constable and put him on the Brady List? Because now his political opponent can say, well, so-and-so is running against me and he's on the Brady List. And then they'll start saying things that are misconceptions, which we'll talk about in just a second. And it's being used as a political tool when it hadn't been a problem for 20 years or 10 years. And I've got examples of things being brought up when somebody was going to take a position in another department that somebody wanted their friend to have. Then they start bringing up, well, he lied on this, report, and so we need to put him on the Brady List.
Is it simple disciplinary issues? For instance, let's just say that, because I'd heard this and I've taken legal calls on it. I had a guy in the I don't want to say the name of the city, a very large metropolitan city in the southeast side of Texas, starts with an H, ends with an N, okay, may have called in to go to a baseball game, called in sick. Calling in sick is not something that I think every single listener, watcher, viewer, everybody's done that and may have not felt 100%, if you track what I'm saying, and gone to the baseball game. A certain supervisor watched this person on the baseball TV, saw him at the game. He was Brady'd for that. That's not, in my opinion, that is not a Brady offensible type situation.
And that's a good point because, I've had that exact same scenario. Officer takes off, goes to Six Flags. Wife posted on Facebook, look, we're having a great time at Six Flags. Everybody sees that he's at Six Flags and not sick. And I think that gets to the gray area here, because if you take the Brady law and to the extreme, anything that you say is untruthful would put you in the disclosure category that would have to be disclosed to the other side. But in reality, everybody out there, including probably all 12 people on that jury panel, have done the same thing.
Yep.
And they don't consider that untruthfulness, even though, it by definition, and it depends on which definition of untruthfulness you use, it is a untruthful statement that was put on a police document that was used and became part of a government document. So the problem that police officers have that someone that outside of law enforcement does not have is that everything they touch is a government document for the most part.
Yeah.
And, the example that I use contra to that is, your supervisor says that there will be no overtime. So your shift starts at 6 in the morning. You get there at 5:45. You clock in at 6 o'clock. So you don't report overtime. You've just given the city 15 minutes, but you've lied. Technically, you've lied.
Yeah.
Because you have you falsified a government record. You said that you got there at 6 when actually you got there at 5:45. And I think that's where one of the things that I'm trying to get people to become more aware of is we got to get back to the days of reason, and let's use some common sense here and quit taking things to the extreme and making everything political. Do you really think that that's going to make a difference in a guilt or innocent verdict?
Yeah,
it's probably not going to. In fact, I represented a doctor who did that very same thing, and they were trying to keep her from testifying. And I said, get up there and say it. Tell a jury that you did that. And I guarantee you that, to the extent I can guarantee anything, I guarantee the jury's not going to care because 12 of the people on that 12-person panel probably did the same thing last week.
Yeah.
So let's get back to being reasonable here. And listen, part of the problem with politics is they're not always reasonable. So technically that would be a violation that would require disclosure. But that's what I think the problem has shifted to this extreme, that it's being abused. I think that's an abuse of the system. You've got a rule that says we got to do this. I'm going to use that to get somebody fired and or put them on the Brady List. And to me, that's not reasonable.
Yeah.
That's something you say, don't do that again. And you discipline them or whatever you have to do. So part of the problem, in addition to the politics that come into it, is the ability to abuse it, because there's a lot of gray area. And most of the stuff is going to fall in the gray area. Mm-hmm. But there are some things that are so blatant that everybody knows if you falsify your probable cause affidavit,
right,
and somebody gets arrested, you should be put on the disclosure list.
Yep.
But if you accidentally put that you reported to work, you came in at 6:12 and you came in at 6 a.m., does that make you a liar? No, it makes you a human. And so I don't think that that's the type of thing that the law was intended to cover. But the last part of the problem is there's no way to get somebody. There's no way to fix that. Once you put somebody on this, whatever this disclosure list is or whatever this panel is, there's no way to get them off.
Yeah.
And we've gone and had conversations with the district attorneys. We've gotten polygraphs. I've had assistant chiefs go talk to the district attorneys, and it's complete discretionary. Sometimes they pull them off. Sometimes they don't. Sometimes they put them on, I will disclose, but we'll still call you as a witness list, as opposed to we're going to disclose and we'll never call you as a witness because, you falsified 5 PC affidavits. So that's another part of the problem is there's no standardization, there's no uniformity, and it's done different in every county that I deal with.
In my opinion, I think that the district attorney, which I think for the most part across Texas, and what I see, in my opinion, is that our biggest problems are at the larger cities, okay? And because larger cities are becoming far left. That's just the reality. That's the reality in Texas, is that our larger cities are becoming woke and they're becoming far left, and they are starting to scrutinize police officers. The district attorneys, for the most part, in the state of Texas, have been given far too much responsibility. Now, for far too long, these district attorneys have treated that responsibility with care and respect. And now that we're seeing that they're not treating that with the respect that it's needed. What I find interesting is police officers and our members across the state are scrutinized from the general public, from sometimes their own administrations, and now from the district attorneys. Police departments have to release stats, UCR reports, body cam footage, everything that they do from the start of their day to the end. Everything is recorded. Everything. On video, on cameras, whether it's in their police department, everything is on camera. Audio, video, period. These district attorneys that put these guys on these Brady lists have too much power. But where's their recordings of these mistakes that they make?
And that's one of the things that I was going to mention later is, how do we fix this problem? And it's based on the quality of the individual that gets elected into the district attorney's office. And I've seen it abused in smaller counties almost worse than in the bigger counties.
Really?
Because in the smaller counties, you have a DA and a couple ADAs, and then you have elected officials, sheriffs, constables, the chiefs. They're all, and even though the chiefs aren't elected, they're still most of the time in a political position because they answer to a city manager or city council. And I see it abused on a regular basis in smaller counties. A lot of the larger counties have a process where it's vetted before it's put on the list. I know one of the counties near us has a panel. It's got an ADA, it's got a DA investigator, it's got a former law enforcement, longtime police officer, and somebody else. And this 4-person or 5-person panel listens to the testimony or the evidence and looks at it and then makes a recommendation. And then that person will get put on the disclose but call to testify, or the disclose and we will not call them as a witness list.
Well, that's a pretty good problem. I mean, that's at least a process.
That's a process, and you've got 4 or 5 people that are looking at it. And I think most, I don't know how Dallas does it, but I think that's similar to how they do it in Dallas. And that's the way it's done up in our area. And so I think that's pretty fair. But when you have a district attorney that can say, I'm putting you on the Brady list and I'm not going to ever allow you to testify in my cases, and I started looking for somebody that oversees the DAs, and I can't find anybody. No. Maybe the state bar does, but they don't seem to compelled to go after the district attorneys. Now, if one of the ADAs messes up, that's different, but the elected status of a district attorney gives them some type of, hands-off approach from law enforcement as well as from other politicians. And district attorneys are politicians. They get elected, and they've got to answer to people, and that is the problem right there. If they decide to put somebody on their disclosure list and try to ruin their career, there's nobody that we can appeal to other than the masses, the election, the people who elect them. Mm-hmm. And that I found yet, and I'm still looking because I'm trying to find a way to deal with a couple of these rogue DAs in a couple of my cases. And they exercise complete authority, and they're unaccountable, really, and it's kind of scary because you can indict a ham sandwich, and you can get somebody indicted, you can put somebody on a Brady list, you can ruin their career, not even mentioning what you do to them mentally when you put a police officer on a list like that, and when we haven't even touched that part of it.
Yeah,
but that is part of the problem, and I think there's a lot of misconception out there about what the Brady List is. First of all, there is no official Brady List. We've tried to ask for an open records, and we haven't gotten one yet. We're still trying to figure out if we can give us the people that you put on your list and why, the process involved, so that we can look into it to see if there's anything that we can do. And then so far, the AG's office has not compelled a district attorney that I know of to produce their Brady List data.
Do you know of any DA's office in Texas that has an appellate process for the Brady List at all, whatsoever?
I don't know of any. I know of a few that have the vetting process that we talked about, but
not an appellate process.
No, and I consider Tarrant County to be a pretty reasonable county when it comes to that, and I've gone to their folks that are in charge of the Brady material and appealed to them like, hey, I've got a polygraph, I've got a file, can we come sit down and talk to you? And they'll listen to you, but in the end, this shall release language is so powerful that they fall behind that and say, hey man, I got to turn it over. And they don't want to take the chance that if they don't turn it over and then someone gets convicted and someone raises that issue that they've got a bad conviction. So there's no way to appeal it at this point in time.
So you mentioned a while ago that you've seen an increase within the last several years of the Brady. Was it the spark of the Michael Morton? And for the listener, viewer, watcher that isn't really familiar with the Michael Morton Act, you may not know this. I was a detective for many years, and then was over an investigation unit. Anytime that you write down any notes, anything at all on a traffic stop, as an investigator, detective, technically that note should be attached to the case file and submitted to the district attorney's office. That's all a part of the Michael Morton Act over a mishap through a district attorney's office some years ago. So when that act was established, is this what we're seeing as a result of the Michael Morton Act with the, I guess, not enhancement, but the encouragement or the I'm trying to look for the words, the increase in the Brady lists?
I think a lot of it has to do with that. It's a multifactorial problem. I mean, momentum has been building for years on this, and it all just hit the perfect storm, and we started getting this legislation, and we started seeing an increase in the Brady cases. Now, I tell a lot of my officers, I know you're going to worry about it, but try not to, because in 5 years, it's not going to be a big deal. Everybody's going to be on the Brady list in 5 years anyway, so it's not going to make any difference. And I think that, that's not necessarily true if you lose your job and you can't get hired somewhere. So I understand that. But, generally speaking, there's a lot of energy in it now. The energy will eventually run down, I hope, if we can't get a fix to it. And the more people they put on the Brady list for the more, mundane reasons, the less effect it has.
Yeah.
And I think that it's going to, in the end, it will potentially help do itself in because of the abuse. Now, part of the problem is the misconception that if you're on the list, you can't testify. I mean, I have officers call all the time and say, I tried to get a job so-and-so, and the chief said he can't hire me because I can't testify, or it's illegal to hire somebody on the Brady list. And that's not true. The disclosure law is just that. It's a discovery in a criminal case. In other words, the things that I can get in discovery in a civil case or a criminal case may be 90% more than what I can put in. If I get 100% of evidence, I may put in 10% of it.
Yeah.
And the other 90% may be inadmissible. So one thing that needs to be carefully looked at in a Brady situation is keep it in its proper perspective. It just requires the district attorney to disclose the information. Now, if they want to go a step further than that and say, I'm never going to call you as a witness, then, and I'll talk about that later, that should be on them. If they want to let the bad guys go, and stand behind this as a reason to do it, then let them do it, and they should be called out for it. Let the police officer do their job and present a case, because just because you get disclosed doesn't mean it's admissible. Like in Tarrant County, I've had officers that have been on the Brady list testified 5 times. And one officer was accused of something. He went through the internal affairs process. Internal affairs sustained all the allegations. We challenged it in arbitration. We won. And he just takes that arbitration decision with him to the courthouse and shows it to the judge. And so the DA there will disclose. Then they'll file a motion in limine to keep it from going in front of the jury. They'll fight to keep it out of evidence.
Yep.
And then if the judge allows it in, then they've done everything they can do. But they don't. They were telling me that they're not going to let a bad guy walk just because a police officer got some discipline. Because in the end, the jury decides credibility,
Yep.
and that's really all the Brady list is it goes to the officer's credibility.
Yep.
Unless they get convicted of a felony.
Right.
And that's a whole different ballgame. But if we got an officer who's accused of untruthfulness, and he gets sustained at the internal affairs or the department level, and it goes to the DA's office, then the DA has the option of trying to keep that out of evidence, because under Rule 608, the only evidence of truthfulness is reputation for untruthfulness.
Right.
You can't get into the specific instances of conduct unless it's a conviction, and that's in Rule 609. So, one incident on the Brady list going to allow someone to say, well, this officer has a reputation for not being credible? So just because someone gets on the list doesn't mean that they can't testify, because the rules of evidence still apply. And even if it comes in, like in our example of calling in sick, the jury gets to decide the credibility of the witness, and they may decide, you know what, he messed up on that occasion or she messed up on that occasion, but they're not a liar.
That's right.
And that's what I think should be done, and that's what I see a lot of the people around us that are doing it like that. So that the heads of the department need to be educated on what Brady is and what it's not, and it doesn't mean you can't testify.
Well, and that's what we're trying to push right now for legislation to be changed. I know that we're working with our legis team right now. There is some talk and discussion with bills trying to be pushed for that appellate process, which I think is very, very, very important. But to also maybe relinquish or kind of repeal or pull back some of that authority with the district attorney and not give them so much power. Because these sheriffs here in Texas think that they're the God Almighty and law enforcement guy within the counties. But the reality is the district attorney is the sitting, they are the highest power law enforcement officer within that county.
And think about this. The district attorney is part of law enforcement. Mm-hmm. I mean, they're the highest ranking law enforcement officer,
Yep.
Not peace officer, but law enforcement officer in that county.
Yep.
They have the power to reject or take any case. They're the only person that can actually try that case and get that conviction. And so, they need to be more accountable, and that's what we were talking about earlier. There's no oversight of the district attorneys in that situations. If one of the things that we can do, I think we can, number one, we need to make the district attorneys more accountable. And there's got to be some agency that oversees what is going on, because it eventually affects the ability of a department to provide public safety. If you've got a DA dictating who can and cannot be hired because of the Brady List issues, and which is in fact what they're doing in some of these cities. You can't hire that officer. I'm not going to call him as witness. You can't hire that one either because I'm not going to call them as a witness. You got the DAs running the police departments, and that's not right. So we could do that. We could make DAs more accountable by having some kind of oversight, or actually we start calling them out when they are going to let a bad guy go just because somebody reported a police officer lied. Take this example. Most of our cities aren't local government code 143. There's no objective appeal process. If someone says you're lying, you go through the internal affairs process and they conclude you're lying, then you're lying. And that gets reported to the DA, and there's no objective evidence of it. It's all speculation and conjecture. If that, most time it's vindictiveness. And so there's got to be something that can be done about that in 3914.
Yeah.
Which cases are going to put police officers on the Brady List that are going to rise to that constitutional protected area? Is it one police officer's opinion, one chief's opinion, or do you have to have an arbitrator or a panel or a commission decide that the person was untruthful? I mean, we could redo 3914 to define what situations are covered on the impeachment part of it, because by and large, most impeachment evidence is probably not admissible in reality.
Yeah.
All the things that you'd like to impeach somebody with, most times not even relevant.
Yeah.
So, and I think that there's 3914 could require an appeal process, some kind of objective review by somebody outside of the district attorney's office.
Well, I think that the legislation, or the piece of legislation that we were discussing with our ledge team, was either the district judge or somebody higher than the district judge.
It could be a district judge. It could be even TCOL, or it could be State Office of Administrative Hearings.
Yeah.
I mean, if you can appeal your driver's license to State Office of Administrative Hearings, why couldn't you appeal something this important to them as well? And that's not, I mean, that's a non-elected person that is a lawyer that's making a decision. It's better than what we've got right now.
That's right.
And because if you get terminated for untruthfulness, you can file your SOA appeal, and if you win, then you can use that.
Yep.
But if they bring it up 20 years, from when it happened, and you're still there, you're not. There's no way to challenge that. We've got to educate our department heads on what it is and what it's not, and they need to start fighting for officers that they believe in that get wrongfully put on any kind of disclosure list. I've got that situation going on right now. Officer gets terminated for untruthfulness. There's absolutely no objective evidence for it. In fact, the objective evidence is exactly opposite of that. And another department looked at that file and said, this is purely retaliation for something you've done. We don't place any merit on it, and we're going to hire you. And they did. And then the department sends the information to the district attorney. New employer goes to the district attorney to fight for its officer. And I've seen that happen a couple of times. Most department heads don't do that. But they could do that. They could start standing up and saying, we're not going to fire this officer just because you're not going to use him. We're going to let this officer do his or her job, present that case, and if you choose not to do your job and you choose to let the bad guys go and you want to blame it on this officer who was untruthful based on conjecture and speculation, then you need to answer for that.
Yep.
So we got to have some way to fix this problem.
Yeah.
In my opinion.
I agree. Well, so you've touched on Brady. You've represented a ass ton of law enforcement officers with TMPA. What would the much older, wiser Randall Moore tell the younger Randall Moore about law enforcement, representing officers, what would you tell the younger Randall Moore 20 years ago, starting in this profession?
I would say tape your ankles and prepare to play hurt. And don't get into it unless you're ready for a fight.
Yeah.
Because you got to define victory.
Yeah.
And victory is not always defined with wins or losses. Victory in these cases to me is have I done my best job for my officer? Have I given them a voice? And do they feel like they had a voice even if they didn't win? That's what I would tell the younger people who think that winning a case is the measure of victory, and it's not. Winning a case is great, and to some degree you have to win to keep doing the job. But if you base your level of satisfaction and success on whether you win or lose in this job, you're going to be sorely disappointed.
Yeah. Well, you got anything else?
Now, what I would, whenever I speak to POAs, I tell police officers, they want to know, what is it that gets officers in trouble more than anything? And I tell them that if it weren't for social media and girlfriends, I wouldn't have a job. So that's not hard to remember, those two things.
Yeah.
Social media and girlfriends is what keep me in business. And everything you touch is a government record. Everything you say is something that someone's going to evaluate your credibility for. And, if everybody else is doing it, and it's, ask yourself, when is it not going to be okay? And if you can't define the time that it stops being okay, then it's not going to be okay when it's not okay.
That's right.
So don't do it.
That's right.
Just do the best you can, trying to follow the rules and regulations, and you're always going to step in it somewhere. But if you're motivated to do the right thing and you're careful and you acknowledge that there are landmines that you can step on, and this is one of them, then that's something you can avoid if you see it. So that's the best advice I can.
A solid advice to give, and there's some truth behind it, believe me. As a guy taking legal calls, there is some truth behind that. Well, listen, I'm going to shoot off 3 rapid-fire questions. Okay? You ready?
I'm ready.
Best line from a cop movie or best cop movie? Best police vehicle? And best adult beverage?
All right, best line from police movie is Mel Gibson when he says, maybe 5 people in the world could have made that shot. I've always changed it to 3, and it may have been 8, but I tell people like 3 people in the world could have made that closing argument.
Yeah.
And so I live that line. I think it was the second movie that he made when he was a cop. I can't remember the name of the movie now. It's, but you know which one I'm talking about.
Yep.
And then best police vehicle.
Mm-hmm.
The one you're not riding in.
Okay. Never heard that answer before.
The one I'm not riding in.
Yeah, that's a good one. That's a good one.
I like the DPS Mustangs.
Yep.
The
late 80s model?
I think that was the way to go.
5.0s.
Right.
Yeah, those were awesome.
And then best adult beverage, tequila.
There you go.
The good kind.
The good kind.
The kind with a little bell on top.
Yeah.
Ding the bell.
Yep. With the worm.
That's right.
That's right. Well, brother, man, I've had a blast. This has been a good episode. Great topics that we've touched on, and man, they're in important topics. Things that needs to they need to change. Honestly, they're just important to our profession. So, you got anything else?
I think we're good. I think we just got to keep fighting the fight.
That's right. Well, Blue Grit family, this wraps it up. You guys hit that subscribe button and, again, download these episodes. Again, it kind of gives us a measure of our analytics. You guys stay safe. God bless you. And as always, may God bless Texas.
Be safe out there.
We're out.